Robert Kirkman lost his Walking Dead lawsuit. What Walking Dead lawsuit? How did he lose it? What the heck does this all mean? Well, he still has the Walking Dead comic. He's still getting a lot of profits from the TV show. He's just not going to get extra profits that he was hoping to be able to get from it. We will get into this article and go over it. We'll also get into the original lawsuit and what it was all about. But first, if you want to support my work, go to collegeofthedead.com. The link's in the description. It's a 48-page full-color comic, College of the Dead Graduation Day. It's the second in an ongoing series, and there's also the prequel there, so you can see what happened before the current issue. Those are shipping immediately. And coming up is The Mermaids. It's at epicmermaids.com. It's not available yet for sale, but sign up for the mailing list, and then you'll get to find out when it launches, which would be great to have you on there. It's going to be like Game of Thrones with mermaids. You'll love it. Getting back to the article, AMC, this is coming from Variety. AMC wins key ruling in Walking Dead profits fight. So a judge on Wednesday handed a significant win to AMC Networks in its long-running battle over profits from the Walking Dead TV show. Now, what was this lawsuit all about? The lawsuit, the Walking Dead producers sue AMC Networks over profits from the hit series. So what are they talking about? In Hollywood, Hollywood is famous for having what they call Hollywood accounting. And they always find ways of coming up with crazy extra expenses so they can claim, hey, yeah, we made profits, but now we really didn't make profits. And then you don't get paid as much as you feel like you're supposed to get. This article started this way. AMC's monster at The Walking Dead has sparked another lawsuit, this time from producers who say AMC is shortchanging their profit participation stakes through self-dealing. All right, now self-dealing means because the company is in a position of control, they are the distributor and they're also the manufacturer of the show. They're able to kind of create financial arrangements between those two companies and kind of make it so that AMC it has advantages that the creators don't have, the producers don't have when they set the deal up. Basically, he who's in control of the money is winning. Walking Dead comic creator Robert Kirkman and his fellow executive producers Galen Hurd, Glenn Mazzara, and David Alpert maintain AMC failed to pay fair market value in the license fee for the series because the show is produced by its in-house AMC Studios arm. The suit filed Monday in Los Angeles Superior Court also involves the spinoff Fear the Walking Dead and the Talking Dead After Show. The suit echoes the accusations in the bitter legal fight with that original Walking Dead showrunner Frank Darabont has waged against the cabler for the past few years. Ironically, it's like lawsuit. As soon as there's money to be made, lawsuits everywhere, right? Lawsuits everywhere. Ironically, in the most recent round of motions in the Darabont case, AMC pointed to what it depicted as the acceptance of the license fee definition by Hurd and others as evidence that Darabont's position was unfounded. When the production company and the network are part of the same conglomerate, as AMC Studios and AMC Networks are here, there's a powerful financial incentive to keep the lion's share of the profit at the network level and not pay a fair market value license fee to the production company, thereby depriving profit participants, like plaintiffs, of their fair share of the series' profits, the suit states. AMC called the filing opportunistic in a response that it suggests it will battle the foursome self-dealing claim as vigorously as it's defended its actions in the Darabont case. Yeah, Frank Darabont has a whole other separate lawsuit. He was the original producer on the Walking Dead TV show. And then they threw him out for season 2. And now he wants all sorts of profit sharing because they felt he was unjustly fired off the series so that they could keep his profits. These kinds of lawsuits are fairly common in entertainment, and they all have one thing in common. They follow success. Hey, just what I said. AMC said in a statement, virtually every studio that has a successful show has been the target of litigation like this, and The Walking Dead has been the #1 show on television for 5 years in a row, so this is no surprise. We have an enormous respect and appreciation for these plaintiffs, and we will continue to work with them as partners, even as we vigorously defend against these baseless and predictably opportunistic lawsuits. On Tuesday, Hurd and Alpert filed a nearly identical complaint against AMC in New York State Supreme Court in accordance with the adjudication provision of their AMC contracts. Attorneys have requested that AMC waive its New York jurisdictional right and consolidate the case with the California filing. Interesting. This would mean they would combine the lawsuit all in one state of California. We will see. In response to AMC's statement on California's lawsuit, Heard, Kirkman, and Alpert said, while we disagree with AMC on the merits of our lawsuit, we appreciate its statement that it will continue to work with us as partners on the continued success of The Walking Dead, Fear the Walking Dead, and Talking Dead. We also reaffirm our commitment to make the best programs possible and sue each other into oblivion if possible. It's amazing they can be suing each other and talking about how each other are ripping each other off, but at the same time, well, we're working together and we're saying, hey, yeah, we want to still collaborate. Like, oh my God, could you imagine? The lawsuit from the foursome hinges on the dispute over the calculation of imputed licensing fee for Walking Dead, a number derived for the purposes of profit participants because the network does not formally pay the studio a license fee, as it would be the case if the show was hailed from an outside studio. So in other words, there's no licensing fee that AMC is paying to a production company because it's internally, the production company is owned by AMC. So they have to come up with an approximate or an estimated licensing fee, and this is what they're disputing. Should it be 6%? Should it be 8%? Should it be 15%? Can you imagine that this wasn't like clearly outlined in a contract? Truthfully, it probably was outlined. They're just disputing the licensing percentage. But obviously, like Marvel does, you know, if you are the producer and you own the content, you're going to have a lower fee for the production company. But if that's because it's your content, that's why you bother having a production company if you're a studio. But at the same time, it's got to be spelled out in black and white. Everybody has to know what they're agreeing to up front. It's only fair. Instead, the initial imputed licensing fee was set at 65% of production costs with a cap of $1.4 million for the first season with 5% bumps per season thereafter. The lawsuit maintains that the current imputed license fee for the show, which will begin its 8th season in October, covers only 68% of the production costs. For such a huge hit, Walking Dead is the highest ranked series in adults 18 to 49 in all of prime time. Wow. The license fee would be much higher if the show was licensed from an outside studio. Okay. The plaintiffs maintain that the lack of a fair licensing fee artificially limits the value of their profit participation stakes. The suit also contends that AMC has improperly deducted expenses from the pool of money available to profit participants, including the costs of paying each profit participant. Okay. This is kind of interesting. So Kirkman's deal with AMC calls for him to receive 5% of the modified adjusted gross receipts from the show, which is essentially profits after you deduct production and other costs from the revenue derived from the show, according to the complaint. Heard was to receive 7.5%, while Alpert was entitled to 2.5%. Charles Egley, a former executive producer of Walking Dead, who is not formally a plaintiff but is included in the complaint, was to receive 2.375%. Mazzara, who served as showrunner in 2011 and 2012, was to receive 1.5%. The showrunner runs a lot of the day-to-day show on the production. Kirkman and Heard had the same stakes in Fear the Walking Dead. All 5 participants also had the most favored nations clauses in their contracts, stipulating that no profit participant would receive a more generous definition of the revenue that comprised the modified adjusted gross receipts. So what that's to say is that no one who is sharing percentages would have a different definition. Like, all right, Heard gets 7.5%, but her 7.5% is really 15% compared to Robert Kirkman's 5% somehow, for example, if she was getting a more favorable definition of what was and what wasn't considered cost or profit. This stuff fascinates me. I'm sure you love it too. The nitty-gritty of that definition and a recent adjustment made to another point of contention between the producers and AMC. Okay, among other claims in the filing, and then we're going to find the results of this, which is the cool thing about going back into an older piece and then getting the current piece. Among other claims in the filing, AMC received $22.8 million in revenue from Apple's iTunes licensing for the show for paid downloads. Wow, that's a lot of money. through 2014, but only reported $4.6 million of that sum as profit to be shared by the participants. So somehow AMC took took 22.8 million and said, all right, we had a lot of costs on that 22.8, but we wound up with 4.6. Let's split the 4.6. And the profit participants are like, hey, wait a minute. You got 22.8. We want our little 7.5 and 5% and 1.5 off the 22.8. We don't want to be knocked down to 4.6. You could see their argument. AMC's double dips on distribution fees for international licensing and home video sales of the show by imposing its own 10 to 20% distribution fees on top of the 12.5 and 20% fee charged by Starz for home video and the 5 to 12% fee charged by Fox International channels. So when you get an international version of The Walking Dead, and you pay someone a fee to put that deal together, Starz over here, right? You don't want an additional fee reducing the overall profits coming from AMC. That's what they mean by double dip. AMC charges a whopping 50% distribution fee for merchandising sales on top of the fee paid to a third-party licensor. So they're taking half as overhead. So if they got $5 million in licensing from toys or whatever it would be, books, not the graphic novels, but just to say toys, posters, T-shirts, AMC is saying before they want to split that with their profit participants, they're taking 50% of it for themselves. Kirkman maintains that AMC has failed to pay him contractually obligated royalties as the owner of the underlying Walking Dead property. I mean, they either did or they didn't. So if you have I have College of the Dead, right? And I own that property. I created it. I invested in it, et cetera, et cetera. I own it. So let's say we made a movie based on it, someone needs to acquire the intellectual property rights for the right to make a movie. Either they buy it out or it's a licensing fee or something like that. Usually it's a licensing fee, although sometimes a studio could outright buy the intellectual property. That's different from if somebody has a role as a producer in helping to make the actual TV show or a movie. So what Kirkman is saying here, supposedly, as I'm reading it, is that yes, they paid him something as a producer. He wants more money as a producer, but he also wants the payments he was supposed to get for them acquiring the rights to make the Walking Dead TV show, which could be millions of dollars all by itself, or it could be a nominal amount of money. I don't know. Kirkman accused AMC of violating the terms of a merchandising agreement that gave him control over certain products such as video games, dolls, and action figures. So, sometimes when you own the intellectual properties, you get to say, well, I'm going to license these things. You can make the movie or the TV show, but you can't make toys. You can make certain toys, but not other toys. Or, as this talks about giving him control over certain products, it may be that he may not have exclusivity, let's say, on video games for video games based on the existing comic series, but he may be able to have a say on the quality of them or approving the video games and things like that. Gets a little complicated, obviously. I don't know all the details, but that's interesting. But here's the ruling. So AMC pretty much won this case. A judge on Wednesday handed a significant win to AMC's networks in its long-running battle over profits from The Walking Dead. Los Angeles Superior Court Judge Daniel Buckley held that the cable network was entitled to define modified adjusted gross receipts under the terms of its contracts with profit participants. Definitions matter. Definitions matter a hell of a lot. So if Kirkman and that producing team signed a deal with the production studio, and they said, okay, you're the production studio, you're making the TV show, but another network is going to distribute it, even if it's AMC's network. When you say when you say we're going to split profits based on modified adjusted gross receipts, like this says, you better define that, word for word, letter for letter. Now, it probably is defined in the contract. Honestly, it's probably just Kirkman and his people feel like, hey, we can get more. Why can't we take a shot at this? So they took a shot. Comic creator Robert Kirkman filed the lawsuit in 2017, which we just talked about, along with producers Gail Ann Hurd, Glenn Mazzara, and David Alpert. The suit accused the network of lowballing the fee to license the show from its production arm. The suit followed a similar claim from Frank Darabont, we know that, who's seeking nearly $300 million in unpaid profits in a suit in New York. That case is set to go to trial sometime next year. We'll watch out for that one. In the Los Angeles case, Buckley held a mini-trial in February and March to focus on the question of the appropriate MAGR definition. MAGR is, say it together, Modified Adjusted Gross Receipts. Okay, AMC contends that it's been making the correct profit participation payments under its standard definition and argued that the plaintiffs were urging the judge to rewrite the deal after the fact. In a 59-page ruling, I kind of want to read this ruling, on Wednesday. I'm not an attorney. I've always liked legal stuff, though. I really have. So it's kind of fascinating. It's so much creativity, but also strict rules and logic. In a 59-page ruling on Wednesday, Buckley ruled that AMC's position is correct. All of the relevant contractual provisions are unambiguous and demonstrate that AMC's MAGR definition is binding, the judge wrote. AMC's lead attorney, Oren Snyder, hailed the ruling in a statement. Hail ruling! Hail in a statement. Today's decision is a total victory for AMC, he said. The judge found in AMC's favor on all 7 issues that were presented at trial and confirmed that AMC honored its contracts and paid Mr. Kirkman and the other plaintiffs what they were owed. As the court found, these plaintiffs had the most sophisticated lawyers and agents in Hollywood, and they got what they bargained for. We are now turning our attention to the trial in New York, which involves very similar claims by CAA and Frank Darabont, secure in the knowledge that the first court to hold a trial on these issues ruled completely in AMC's favor. That is very helpful to them in the New York lawsuit. But with Frank Darabont, it was a little bit different because he's been excluded from continuing as a producer. So Frank Darabont might say, hey, I don't like your initial calculations while we were working together, but he's also saying that you unfairly threw me off of this just to cut me out of profits. Whether or not they had a right to do that, it depends on their deal, and it's a whole separate issue. But on some bulk of the issues, like does AMC really have the right to define what they mean when they say we're going to pay you modified adjusted gross receipts per however it's defined in their contracts? Yeah, they do have that right according to this court. The Los Angeles case will now go to trial on the remaining issues unless the parties can resolve their dispute at a court. So it's not over yet, but the Kirkman team pretty much lost. So work with good lawyers, get paid a lot of money, and don't ever delegate really important matters just to professionals. It's great to work with sophisticated professionals in legal situations, financial situations, marketing, all that other stuff, but never delegate the responsibility of understanding what the F is going on. You need to, no matter how complicated something is, if you're doing a deal with somebody about something, hire somebody good enough, work with someone good enough to explain it to you like you're 5 years old. If they can't explain to you what's going on, you're going to wind up ripped off one way or another. All right, so just be careful when you're doing deals. Robert Kirkman is incredibly successful. He's made tons of money. He's going to keep making tons of money. He's just not going to make an extra like $400 or $500 million. That, from how I read this, was impossible to make anyway. Other people weren't picking up Walking Dead at the time. It was AMC that took the risk and made the investment and provided the distribution to make it work. So fair is fair. Didn't work. So if you want to support my work, collegeofthedead.com. Get College of the Dead Graduation Day, where college costs you an arm and a leg. It's a 48-page full-color graphic novel. I love how it came out. I think you're going to enjoy it. And sign up for epicmermaids.com. The Mermaids ongoing series. It's going to come out soon. It's Game of Thrones with mermaids. And I will see you again soon with another video. And if I don't see you, I will miss you.